friends, welcome to my channel. Today I am going to deal with the provisions relating to hazardous process under Factories Act 1948. This is chapter 4A. A, capital A. It is introduced by Act number 94 of 1976 Act. Amendment Act. Section 41A to Section 41H is provided under chapter 4A, dealing with the provisions relating to hazardous process. Section 41A provides constitution of site appraisal committee. Constitution of a committee known as site appraisal committee. For what purpose? For the purpose of advising. The state government may. Section 41 subsection 41A subsection 1 provides that the state government may, for the purpose of advising it, the government which will appoint the site appraisal committee is state government, not central government or appropriate government. So we have to remember it. We cannot make mistake here. The state government may, for the purpose of advising it. What is the purpose of this site appraisal committee? Only advisory. It can advise the state government in certain matters. What kind of matters? The matter may relate to consideration of applications for grant of permission. Consideration of application for grant of permission. What kind of permission? Permission for initial location of a factory. Permission for establishment of a factory in any area. Permission for establishment of a factory in an area, which we can say in other words, initial location of a factory. Initial means establishment of a factory in an area, or expansion of any such factory, expansion of any other factory. Expansion means if there is any other factory exists and the factory, they want to expand the factory, then this is called expansion of any other factory, any such factory. Appoint a site appraisal committee. The state government shall appoint a site appraisal committee, and these two kind of factories are the factories which shall involve hazardous process. The word hazardous process is very important. Hazardous process means they will deal with the processes in which it will cause harm or injury to the human being or the environment. So these are the factories which involve hazardous process. So for this purpose, whether the central government will grant permission or not, for this to consider this matter, the state government may take the advice of site appraisal committee. This is the purpose of establishment of a site appraisal committee. And the site appraisal committee shall consist of A, the chief inspector of the state, who shall be the chairman. There shall be a chairman. The chairman shall be the chief inspector of the state. Of course, under this Factories Act, under section 18, inspector and chief inspector, appointment of inspector and chief inspector is provided. So the chief inspector of state shall be the chairman of the site appraisal committee. 2. A representative of the central board. There shall be a representative. The first one will be chairman of chairman. Second is a representative of the central board. Here we have to see one thing. This is central board. This is also central board, but this is state board. So representative of the central board for the prevention and control of water pollution. Representative of the central board for the prevention and control of water pollution, appointed under the central government under section 3 of the Water Prevention and Control of Pollution Act 1974. There is an act which we have read in environmental law, Water Prevention and Control of Pollution Act 1974. Because the factory involves hazardous process, so the representative of central board of Water Prevention and Control of Pollution Act 1974 is required to be there. Then comes C, a representative of the central board for the prevention and control of air. Now it deals with air prevention, and it's about water pollution appointed by central government. It's about air. Representative of the central board for the prevention and control of air pollution, referred to in section 3 of the Air Prevention and Control of Pollution Act 1981. This is also act which we have read in environmental law. Then comes D, a representative of the state board. Now this is the representative of the state board. These two are representatives of central board relating to water and air prevention and control of pollution act. Then this is about state board, appointed under section 4 of the Water Prevention and Control of, this is water again, Prevention and Control of Pollution Act 1974, 6 of 1974. Then E, a representative of the state board. again representative, again state board, for the prevention and control of air pollution, referred to in section 5 of the Air Prevention and Control of Pollution Act 1981. That's all, these things are easy. Then comes F, a representative of the Department of Environment of the state. Now there shall be another representative. He shall belong to the Department of Environment, and Department of Environment not of the center but state. We have to remember the word state. Then G, a representative of the Meteorological Department of the Government of India. Now the representative of Meteorological Department shall belong to the Government of India, GOI, Government of India, not state. Then comes H, an expert in the field of occupational health. Occupational health means the disease which arises out of any hazardous process in industry. So occupational. So an expert in the field of occupational health. Then GHI, a representative of the Town Planning Department. Representative of Town Planning Department of the state government. It is state government, not central. Not more than 5 other members who may be co-opted by the state government, who shall be not more than 5 other members. Apart from this, there shall be 5 other members who may be co-opted by the state government, who shall be, these are Roman 1, a scientist. There shall be a scientist also, having special knowledge of the hazardous process which will be involved in the factory. The scientist must have a special knowledge of the hazardous process involved in the factory. 2, a representative of the local authority within whose jurisdiction the factory is to be established. Local authority. Representative of the local authority within whose jurisdiction the factory is to be established. Then 3, not more than 3 other persons as deemed fit by the state government, and the other 3 persons shall be appointed by the state government. These 2 persons shall be one scientist and another is representative of the local authority, and these other 3 persons shall be appointed by the state government. Total 5 other members. Section 41A subsection 2 provides that the site appraisal committee shall examine on application. What is the function of it? Examine on application for the establishment of a factory involving hazardous process and make its recommendation to the state government. First of all, it will examine an application for the establishment of a factory involving hazardous process. Then it will make its recommendation to the state government here, not central, within a period of 90 days. The time period we have to remember, 90 days of the receipt of such application in the prescribed form. So you will the site appraisal committee will examine on an application for the for the establishment of factory involving hazardous process. Then it will recommend the same to the state government. Time period is 90 days. We have to remember 90 days. Then subsection 3, where any process relates to a factory owned or controlled by the central government. Where any process relates to a factory and the factory is owned or controlled by the central government, or to a corporation or a company owned or controlled by the central government, the state government shall co-opt in the site appraisal committee a representative nominated by the central government as a member of that committee. If the factory relates to the factory itself is owned or controlled by the central government, then the representative nominee of the central government is required to be a member of the committee. Section 41A subsection 4 provides that the site appraisal committee shall have power to call for any information. Call for what? Any information from the persons making an application. Persons making an application. Application may be for what matter? For the purpose of establishing factory involving hazardous process. So from those persons who makes application, that means from the applicant, the site appraisal committee shall have power to call in information from the applicant for the establishment or expansion of a factory involving a hazardous process. Then 5%, because the information are required for the site appraisal committee to decide whether to grant permission, whether to recommend the state government for granting permission or not. That's why information is required. Then comes 5. Section 41 is subsection 5. Where the state government has granted approval to an application for the establishment or expansion, either establishment or expansion of a factory involving hazardous process, it shall not be necessary for an applicant to obtain a further approval from the central board or the state board established under Water Prevention and Control of Pollution Act 1974 and Air Prevention and Control of Pollution Act 1981. Why it's not necessary? Why the further approval not necessary? Because the site appraisal committee consists of representatives of state board of state and central board of Water Prevention and Control of Pollution Act, and also state and central board of Air Prevention and Control of Pollution Act. So a further approval or a separate application and approval is not required. Then comes section 41B, compulsory disclosure of information by the occupier. Occupier means the person who has ultimate control over the affairs of the company. It may be manager as well. So section 41B provides compulsory disclosure of information by the occupier. Section 41B subsection 1 provides that the occupier of every factory involving a hazardous process, the factory which involves a hazardous process, shall disclose in the manner prescribed all information regarding dangers. The occupier shall disclose in the manner prescribed all information regarding dangers, including health hazards. Danger, which may include health hazards, means injury or harm which may cause to the health of any person employed therein, and measures to overcome such hazards. Not only the dangers or health hazards, but also what are the measures which can be employed to overcome those hazards arising from the exposure to or handling of the material or substances in the manufacture, transportation, storage, or other process to the workers employed in the factory. The chief inspector and the local authority within whose jurisdiction the factory is situated, and the general public to the vicinity. So the occupier shall disclose those information to three persons here. First of all, to the chief inspector. Second, the local authority within whose jurisdiction the factory is situated, and the general public in the vicinity, because it's also and also a workman also, four persons. First of all, to the workman who is employed therein. The workman must have knowledge about the dangers, health hazards, and also the measures, and the chief inspector should also know the measures which the occupier or the factory has taken to overcome those hazards arising from the exposure to or handling of material or substances in the factory. And also local authority within whose jurisdiction the factory is situated should also know about those health hazards and dangers, and the general public in the vicinity, because these hazardous substances may affect the general public who lives near the factory as well. So all these persons will be aware of those dangers. That's why it is said compulsory disclosure of information by the occupier. Compulsory means it's mandatory. Then comes section 41B subsection 2. The occupier shall, at the time of registering the factory involving a hazardous process, lay down a detailed policy with respect of the health and safety of the workers. Policy regarding what? Health and safety of the workers employed therein, and intimates such policy to the chief inspector. So at the time of registration, the occupier shall lay down detailed policy, the measures which they have taken to provide for the protection, health and safety of the workers employed therein, and intimates such policy to the chief inspector also. And the local authority, chief inspector plus local authority, two persons, chief inspector and local authority, and thereafter at such interval as may be prescribed, inform the chief inspector and the local authority of any change made in the said policy. So there two persons are only required to know about the policy, chief inspector and local authority, and here four persons. Section 41B subsection 3 provides that the information furnished under subsection 1 shall include accurate information as to the quantity under subsection 1, not 2, not here, but under subsection 1 shall include accurate information as to quantity, specifications and other characteristics of waste and the manner of their disposal. Quantity, first thing. Second, specification and other characteristics, QSOC, of the waste and the manner of their disposal. Section 41B subsection 4 provides that every occupier shall, with the approval of the chief inspector, draw up an on-site emergency plan. Not only the detailed policy for safety and welfare, safety and protective measures of the workers as provided under subsection 3, but also emergency plan and detailed disaster control measures. This is in case of emergency, and detailed disaster control measures for this factory, and make known to the workers employed therein and to the general public living in the vicinity of the factory, and safety measures required to be taken in the event of an accident taking place. So the occupier shall again, with the approval of a inspector, draw up an emergency outside emergency plan and the detailed disaster control measures for his factory, and the same make known to the workers employed therein and to the general public also, workers general public also living in the vicinity of the factory, and safety measures required to be taken in the event of accident taking place. Then comes section 41 subsection 5. Every occupier of a factory shall section 5A, if such factory engaged in a hazardous process on the commencement of Factories Amendment Act 1987 within period of 30 days of such commencement, time period is 30 days, we have to remember it. B, if such factory proposes to engage in a hazardous process at any time after the commencement within a period of 30 days before the commencement of such process, inform the chief inspector of the nature and details of process in just from and in just manner as may be prescribed. Then comes section 41B subsection 6, where any occupier of a factory contravenes the provisions of subsection 5, that means these provisions. License issued under section 6 of such factory shall, notwithstanding section 6 of such factory shall, notwithstanding any penalty to which the occupier of factory shall be subjected to under the provision of this act, be liable to cancellation. So that means the license shall be liable to cancellation plus this shall be subjected to penalty. Section 41B subsection 7. The occupier of a factory involving a hazardous process shall, with the previous approval of the chief inspector, lay down measures for handling, uses, transportation, and storage of hazardous substances. Substances means hazardous substances. So lay down measures for handling, uses, transportation. How to handle it? Uses and transportation. How to transport it from one place to another. And also storage. Handling, uses, transportation, and storage of hazardous substances inside the factory premises. Inside the factory premises, and the disposal of such substances outside the factory premises, and publicize them in the manner prescribed among the workers and the general public living in the vicinity. This is about hazardous substances. Handling, how to handle this, uses, how to use this, precautions regarding its uses, and transportation, because for this there also safety have to be followed, and storage of hazardous substances inside the factory, and also disposal of such substances outside the factory premises, and publicize them in the manner prescribed among the workers and the general public living in the vicinity, because the workers and general public should also be aware of it so that they can be safe, they can be protected from it, protected from hazards of the hazardous substances. Then comes section 41(6), 41C, specific responsibility of the occupier in relation to hazardous process. What are the responsibility the occupier has? So, every occupier of a factory involving any hazardous process shall: A, maintain accurate and up-to-date health records. The health records should be accurate, up to date. It should be maintained timely. Health records, or as the case may be, medical records. Health records plus medical records of the workers in the factory who are exposed to chemical, toxic, or any other harmful substances which are manufactured, stored, handled, or transported, and such records shall be accessible to the workers. And these medical records and health records and medical records shall be accessible to the workers subject to such conditions as may be prescribed. So this is about health of the workers working in factory involving hazardous process, and this is the responsibility of the workers to maintain those records, health records, medical records, and it should be accurate and up to date. B, appoint person who possesses qualifications and experiences in handling hazardous substances. Appoint person who possesses qualification and experiences in handling hazardous substances and are competent to supervise such handling. Within the factory, and to provide at the working place all the necessary facilities for protecting the workers in the prescribed manner. So a specially trained person, qualified or experienced person shall be appointed who is experienced in handling hazardous substances, as well as who can supervise and provide necessary facilities to the workers for their protection. Provided that where any question arises as to the qualifications and experiences of a person to appointed, the decision of the chief inspector shall be final. That's all. Then comes clause 6, section 41C, clause 6. Provide for medical examination of every worker. Roman 1. Before such worker is assigned to a job. Now, Roman 1 deals with before such worker is assigned to a job. Roman 2 deals with while continuing his job, and in both cases medical examination is required. So that means before such worker is assigned to a job involving the handling of or working with hazardous substance, and 2, while continuing in such job and after he has ceased to work in such job, not only while continuing such job but also while he has ceased to work in such job, an interval not exceeding 12 months in just manner has been prescribed. So medical examination of the workers before assigning such job, while continuing such job, and after cessation of such job. 3 stages. Then comes section 41D, power of central government to appoint inquiry committee. That is important. Section 41D, power of what government? It is central, not state. State government shall appoint side appraisal committee. Now this is central government which will appoint inquiry committee. The name inquiry it itself says that thus may be incurring something. So section 41D subsection 1. Section 41D subsection 1 provides that the central government may, in the event of occurrence of an extraordinary situation involving a factory engaged in hazardous process, extraordinary situation, appoint an inquiry committee to inquire into the standard of health and safety. Inquire into what? Standard of health and safety observed in the factory with a view to finding out the causes of failure or neglect. First of all, they will inquire into the standard of safety and health in the factory. Second, what is the purpose of this inquiry? To find out causes of failure and neglect in the adoption of any measures or standard prescribed for the health and safety of the workers employed in the factory or the general public affected or likely to be affected. And also inquire how the general public is affected or likely to be affected due to such failure or neglect, and for the prevention and recurrence, prevention as well as recurrence of such extraordinary situation in future. Prevention of such extraordinary situation in future in such factory or elsewhere. So this is the function of inquiry committee. So to inquire into the standard of safety and health measures. Second, to find out the causes of failure and neglect. Third, to find how the general public is affected or likely to affect it. And fourth, to prevention and recurrence of such extraordinary situation in future in such factory or elsewhere. These are the 4 functions. We can break it into 4 points. Then section 41D subsection E. The committee appointed under subsection 1 shall consist of a chairman and 2 other members. 1 chairman, 2 other members. 2 other members, and terms of reference of the committee and tenure of office of its members shall be such as may be determined by the central government according to the requirements of the situation. That's all. Then subsection 3 provides the recommendation of the committee shall be advisory in nature. This is important. It is merely advisory in nature. The inquiry committee shall only advise, and it cannot take cannot give any binding decisions. Just like side appraisal committee also, its function is advisory, recommendation, and advice. Then comes section 41E, emergency standards. Section 41E subsection 1 provides that the emergency standards, this is the title. Section 41A subsection 1 provides that where the central government is satisfied that no standards of safety have been prescribed. Central government now here, not state government. Again, we should not confuse it. Central government is satisfied that no standards of safety have been prescribed. There is no standards of safety in respect of a hazardous process or class of hazardous process, or where the standards to prescribe are inadequate. There are 2 conditions. In first condition, no standards of safety has been prescribed. In the second conditions, the standards to prescribe are inadequate. 2 conditions. In those situations, it may direct the Director General of Factory Advice Service and Labor Institute. This is what? Director General of what? Factory Advice Service and Labor Institute, or any institute specialized in matter relating to standards of safety and hazardous process, to lay down emergency standards for enforcement of suitable standards in respect of such hazardous process. When no standard of safety have been prescribed or prescribed but inadequate, so it shall direct the Director General of Factory Advice Service and Labor Institute to lay down emergency standards. That's all. Then section 4, that's why its heading is emergency standards. Section 41E subsection 2 provides that the emergency standard laid down in subsection 1 shall, until they are incorporated in the rules made under this act, be enforceable and have the same effect as if they had been incorporated in the rules made under this act. That's all. Then comes section 41F, permissible limits of exposure of chemical and toxic substances. Permissible limit. the limit is permissible of exposure of chemical and toxic substances. Section 41F subsection 1 provides that the maximum permissible threshold limit of exposure of chemical and toxic substances in the manufacturing process, whether hazardous or otherwise, the manufacturing process may be hazardous or otherwise, in any factory shall be of the value indicated in the second schedule. So to find out the permissible limit of exposure of chemical and toxic substances in a factory carrying on manufacturing process, whether the factory is hazardous or not, we have to refer to the second schedule of this act, Factories Act 1948. That's all. So for this 41F1, we have to remember, we have to see the title and then second schedule. Section 41F subsection 2 provides that the central government may, this is the central government again, may at any time for the purpose of giving effect to any scientific proof obtained from a specialized institution, giving effect to what? Any scientific proof obtained from a specialized institution or experts in the field by notification in the official gazette, make suitable changes in the second schedule. So section 41F subsection 2 is about making suitable changes in the second schedule, and the central government has the power to do so. Then comes section 41G. Workers' participation in safety management. The word management is used here, and the workers shall participate in safety management. Section 41G subsection 1 provides that the occupier shall in every factory where a hazardous process takes place, where hazardous substances are used or handled, set up a safety committee. Now this is about establishment of a safety committee consisting of equal numbers of representatives of workers and management. So the safety committee shall consist of equal number of representatives of both workers and management. Though the committee shall consist of representative of workers as well as representative of management, but these shall be in equal numbers. Consisting of equal number of representative of workers and management to promote cooperation between the workers and the management. The purpose is to promote cooperation between the workers and the management in maintaining proper safety and health at work, and to review periodically the measure taken in this behalf, and also review those measures, safety measures taken in this behalf, provided that the state government may, by order in writing and for regions to be recorded, exempt the occupier of any factory or class of factories from setting up such committee. First, it is the duty of the occupier to establish a safety committee, but the state government may exempt the occupier from establishing a safety committee as well, if in its opinion or for regions to be recorded things fit. Then section 41G subsection 2 provides that the composition of safety committee, the tenure of office of its members, and their rights and liabilities shall be such as may be prescribed. Then comes the last section, section 41H. Right of workers to warn about imminent danger. What is this? Right of workers to warn about imminent danger. The workers has right to warn the management about imminent dangers. Section 41H subsection 1 provides that where the workers employed in a factory engaged in a hazardous process have reasonable apprehension, they have apprehension, which is reasonable of course, that there is a likelihood of imminent danger to their lives or health due to any accident, they may bring the same to the notice of the occupier. Notice of what persons? First of all, this is occupier. Second, agent, manager, or any other person who is in charge of the factory or the process concerned, directly or through their representative. They may warn those occupier, agent, manager, or other persons directly or either through their representatives in the safety committee. This is the utility of safety committee. And simultaneously bring the same to the notice of the inspector as well. Inspector is mean occupier, agent, manager, other person, and inspector. Then section 41H subsection 2. It shall be the duty of the occupier, agent, manager, or the person in charge of the factory process to take immediate remedial actions if he is satisfied about the existence of such imminent danger, and sent a report of the actions taken to the nearest inspector. Then comes section 41 in subsection 3. If the occupier, agent, manager, or the other person in charge referred to in subsection 2 is not satisfied about the existence of any imminent danger, if they feel that there is no such danger, not satisfied about the existence of any imminent danger as apprehended by the workers, he shall nevertheless refer the matter forthwith to the nearest inspector. Still, they have to refer the matter forthwith to the nearest inspector, whose decision on the question of the existence of such imminent danger shall be final. Still, they cannot take it lightly. they can refer it to they have to refer it to the inspector, and then the inspector shall decide whether exists any imminent danger or not. This was the provisions related to hazardous process. Thank you. Thanks for watching. Please do not forget to subscribe.